Hello everyone, welcome to the Lex.Journey. I am Asampwa Lord and I'll be your contract law moderator. So let's start by defining what a contract is. So a contract is defined as a promise or a set of promises which the law will enforce. A promise or set of promises which the law will enforce. And this was the definition given by Sir Frederick Pollock. All right, so an offer may be general or specific. An offer is specific when it's made to specific individuals or groups. It is general when it is made to the whole world. So an example of a general offer is the one that was made in the case called Carlyle versus Carbolic Smoke Ball, where the offer was made through advertisement to the whole world, and the court interpreted that to be a unilateral offer which can be accepted by anyone who performs the stipulated act. So now let's go to the next point that we have. Now we have to be able to distinguish offers from invitation to treat. An offer is different from an invitation to treat. So before then, we have to be able to define what an offer is. So yes, right now you're asking what an offer is. So to constitute a contract, there are certain elements that must be present. The first is offer and acceptance, traditionally, offer and acceptance. The second is intention to create legal relations. The third is consideration. And the fourth is the capacity to contract. So for today's session, we will be focusing on what an offer is and what the element that an offer must entail. First, what is an offer? An offer is simply an expression of a willingness to contract on specified terms, made with the intention that it becomes binding as soon as it is accepted by the person to whom it is addressed. So, an offeror is a person who is making the offer, and an offeree is the person to whom the offer is made. In Ghana, the most authoritative definition of an offer was given by that bar in the case of NTHC versus YA NP, where he defined an offer as an indication in words or by conduct by an offeror that he or she is prepared to be bound by a contract in the terms expressed in the offer if the offeree communicates to the offeror his or her acceptance of those terms. This is a very all-encapsulating definition given by that bar. He's a very learned man, very learned. So now, what is an invitation to treat? We have to know what an invitation to treat is in order to be able to distinguish an offer from an invitation to treat. So an invitation to treat can be defined as any preliminary expression which shows an intention to receive offers, or in the treaty on contract, it expresses an invitation to treat to be any communication which expresses one's intention to invite offers or receive offers. So, an offer is not the same as invitation to treat. So, the difference between an offer and invitation to treat is normally a hard one to make because it lies in the intention of the party making it, whether or not he wanted an acceptance to conclude or whether he wanted the acceptance to be capable of making the offer converted into a contract. So, however, we can apply general rules of law in order to make this distinction between an offer and invitation to treat. Throughout the years, the courts have made several decisions and now we have certain rules in order to know whether or not a particular thing is an offer or an invitation to treat. The first is advertisement. Generally, an advertisement is an invitation to treat and not a contractual offer, capable of being accepted to conclude a contract. An illustration of this, or this principle, was illustrated in the case of Partridge versus Crittenden. Partridge versus Crittenden. However, there are exceptions to this general rule that advertisements are invitation to treat and not contractual offers. The first is where the advertisement creates a unilateral offer, where the advertisement is in a way that it is a reward or it is an offer of reward to anyone who performs a stipulated act. This advertisement is no longer an invitation to treat, but it is capable of being a contractual offer. And an illustration is the case of Carlyle versus Carbolic Smoke Ball Company. And this view was expressed by Bowen LJ. All right. So the second exception is, of course, where the advertisement contains sufficiently certain terms, or where the advertisement, the terms of it are certain or definite. And this part is illustrated by the case of Lefkowitz versus Great Minneapolis Surplus Stores, the Lefkowitz case. Now we've exhausted the discussion on an advertisement. So generally, they are invitations to treat, not contractual offers, but the exceptions exist and they have already been given. Now, the next is shop window display or display of goods in a shop. When goods are displayed in a shop with prices attached, they are not contractual offers to sell to any buyer, but they are merely invitation to treat. It is merely inviting persons to come and make offers. An illustration to this point is the case of Pharmaceutical Society of Great Britain versus Boots Cash Chemist. And this was later affirmed in the case of Fisher versus Bell. So, even with the display of goods in a shop, it may amount to an offer where such an intention can be inferred from the circumstances. And this was expressed by the court in Chapelton versus Barry UDC. Now, let's go to the next one, which is tender notices. Generally, a notice inviting persons to submit tenders for the purchase of goods or the supply of certain goods doesn't qualify as contractual offers, as they are merely invitations to treat. An illustration of this point is the case of Spencer versus Harden. Spencer versus Harden. So, it's also important for us to, within the tender notices, for us to consider standing offers within this part of the discussion. So, not all tenders, when they are accepted, sometimes a tender may be accepted, but there is still no contract. There will still be no contract. So it depends on the language of the tender that is being submitted. If the language is in such a way like this, that goods will be delivered, or such goods will be delivered as such time when they are being ordered, or if I tell you that I will deliver you certain goods as and when you order for them, when you accept this tender, a contract does not conclude. What comes into effect is what we call a standing offer. And this offer is capable of being accepted anytime you place an order for the goods. And anytime you place an order for the goods, I cannot say I won't supply them. I am bound to supply them, because anytime you order, a contract comes into existence. And an illustration to this point is Great Northern Railway versus Rita. So standing offers too are different from requirement contracts, which I don't have to delve so deep. However, requirement contracts too are what we have to also know under the tender notices. And it will be very instructive to read the case of Purdy versus Attorney General. Now let's go to the next point. Price list or catalogs. So when a price list is circulated or a catalog is being circulated, that certain goods are being sold at certain prices, such a circulation does not amount to an offer to sell to those who order, but it's merely an invitation to treat. And this was expressed in Granger and Son versus Go, where Lord Herschel expressed the view that the supplier is necessarily or has limited stock. So there can't be an intention, or he has no intention, that He's bound by contract as soon as people order for the goods, because necessarily his goods or his stock are limited. His stock are limited in Granger and Son versus Go. Now let's go to auction sales. Generally, or let's say auction sales, when a particular product or a particular property or lot is to be sold by auction, such is an invitation to trade and not a contractual offer. So we have to state the case of British car auction versus Wright, where the defendant was prosecuted for offering for sale an unroadworthy vehicle. The court held that since he was merely selling it by auction, or since it was merely an auction sale, it wasn't an offer to the people, but he was merely inviting people to come and make their offers. So he wasn't offering for sale. British car auction versus Wright is on the point of auction sale. And you may have to also consider other parts of it. Now let's go to mere statement of price. When a person states a price or the lowest price of a particular good, that person doesn't intend to contract at that stipulated price. It's merely stating the price to invite you to come so that you start the negotiation process. So the mere statement of a price is not a contractual offer, but merely an invitation to treat. And this is in the case of Harvey versus Farsi, where the plaintiff asks the defendant, "Can you telegraph me the lowest price of your bumper hole pen?" And of course, the defendant then telegraphed the lowest price to the plaintiff. And the plaintiff accepted that, or accepted to buy the bumper hole pen at the lowest price that was given him. But the court held that the lowest price, the citing of the lowest price by the defendant, didn't mean the defendant wanted to contract, or he wasn't offering for sale at that price, but it was merely inviting the plaintiff to come and make an offer. Now, this is how we will exhaust the distinction between an offer and invitation to treat. So all I will say is that essentially the difference between an offer and invitation to treat lies in the intention which the party making such a communication intended. It depends on the intention. But yes, we have been able to apply certain rules of law where the court have held that generally when certain things happen, they are not offers, but they are merely invitation to treat. So one important thing we have to note about offer is that offers must be communicated. So when you listen to the definition that I gave in NTHC versus CRNP about an offer that Atiba gave, he expressed the view that an offer must be communicated to the offeror before it becomes binding. So yes, offers must be communicated generally. An offer must be communicated. The acceptance of it, or even an offer, making the offer, you have to communicate the offer. So this was in the case of Taylor versus Laird. Taylor versus Laird, where a captain resigned from being a captain and became an ordinary crew member without informing, let's say, the boss or the ship owner. So he wanted to claim wages for his services as an ordinary crew member, but the court held that he couldn't claim because he didn't inform the ship owner of him changing his work from being a captain and a ship owner. So in other words, he didn't communicate his offer to work as a crew member to the ship owner. Thus, there was no contract. So an offer must be communicated. Now let's look at how an offer may be brought to an end, how an offer may be terminated. So the first one that I will start with is lapse of time. An offer lapses after, okay, let's start with this point. An offeror is entitled to stipulate